Bénédicte.
Hi Hélène.
You have been closely following the EU trademark reform, and actually as a member of INTA OHIM subcommittee, you've been following the impact of the trademark reform on OHIM practices and structure. We already know that OHIM will change its name and become the EU Intellectual Property Office. But is there more for trademark users to anticipate than a change of name? I mean, can you tell us a bit more about the impact of the reform on OHIM practices?
Yeah, it is indeed more than a change of name. It's a change that will reflect the new activity of the office, and three main pillars are going to change. The governance of the OHIM, so new structure, new name. The existing cooperation between EU member states and the OHIM will be more precise and grounded in the legislation. And finally, the OHIM practice will change. I can give you just a few examples. For instance, on absolute grounds, the graphical representation requirement is abolished, or in opposition, the opposition period for international registration designating the EU will be shortened. Another important element is a change regarding the goods and services. There will be an express requirement in the regulation for clarity and precision. In fact, all trademark users, owner of a trademark file as from June 2012, will have to file within 6 months of the entry into force of the regulation a declaration to the office defining the goods and services which are now considered not clear, not precise.
Very important indeed. What about the impact of the reform on application and renewal fees of EU trademarks?
Okay, the good thing is, something that INTA is quite happy about, is the renewal fee will substantially decrease. Another thing that's important is a new structure for the filing fee. It will be a one-class filing fee.
Okay, so we know those are just a few of the anticipated changes.
Yeah.
But how do you think OHIM will handle these changes, and actually when can we expect these changes to enter into force?
Okay, the EU regulation will enter into force 90 days after its publication in the official journal. We expect spring 2016. The directive will have to be implemented by the member state within 3 years, with an exception for the cancellation proceedings. Member states have been granted a 7-year delay. The OHIM, they have identified 500 tasks to be performed. One of them will be the modification of the guidelines. They will publish draft guideline on December 14 of this year. Comments can be given until January 22nd, 2016, very short. Everything will be gathered, and the guideline will be published when they are approved by the President, and they will enter into force at the same time as the regulation.
Well, good to know. Well, as the legislative process for the adoption of the EU trademark reform became more fast-paced, INTA set up a rapid response group made up of volunteers committed to provide answers, recommendations, and information to EU institutions and member states at their request. Often, I must confess, under very short turnaround times. And you've been a member of this rapid response group, so I was wondering, what was your experience and what did you gain out of it?
Well, it was very interesting work. We were working on burning issues where we could hope to have an impact. Short deadline, yes, indeed, but we always managed to provide comments, probably because we felt that it was a unique chance to participate in the reform. So a great challenge at the heart of the project, with deeply committed people. It cannot get better than that.
You have been also part of the battlefield by accompanying INTA Europe representative office, including myself, to meetings with EU member states and members of the Parliament to explain and promote INTA positions. What was your experience of having such interactions with actually member states and member of the Parliament?
We met with people with different expertise, and for whom trademark was not their specialty. They were handling many other subjects. It was a very interesting experience. It gave a strong insight into the creation of the regulation, because we often forget that trademark law is part of a greater set of law, which is European law. And then modifying it is not as simple as straightforward as we could hope. There was a lot of contradictory interest at stake. So it was a very, very beneficial exercise, yes.
And well, on a more practical level, I was wondering, what is the biggest change that the EU trademark reform will introduce in your daily practice?
Well, if I have to pick one, there's several of them, but I'm a trademark attorney and I work in the Benelux. So I would say the biggest one would be the implementation of the cancellation proceeding. Because in our case, our clients very often don't have the time to always look at their problem with opposition, and they get too close to the deadline, sometimes to the point of missing it. With this cancellation proceeding system, they will have a bit more time and without having to go to court, which is quite costly.
So a cheaper version. Well, thank you so much, Bénédicte, for your insight.
Thank you very much for having me.